Discordant notes do not resolve a dispute, Justice Sudhanshu Dhulia admitted in his opinion on the hijab ban, before emphasizing that finality is a good thing, but justice is better. A two-judge bench of the Supreme Court delivered a split verdict on Karnataka's hijab ban in educational institutions on October 13th after 9 days of hearing. Justices Hemant Gupta and Sudhanshu Dhulia were not the first judges to deliver opinions on the hijab ban. On March 15, 2022, 3 judges of the Karnataka High Court delivered a judgment upholding the ban after 13 days of hearing. Immediately after this, challenges to the High Court decision were filed at the Supreme Court. For 5 months under CJI N.V. Ramana's stewardship of the court, the case was not heard. Right after taking over, CJI Lalit listed the petition before Justices Gupta and Dhulia. Justice Dhulia declared the ban unconstitutional. However, in his final move before retirement, Justice Gupta upheld it. The site of the dispute, schools, formed the heart of both opinions, albeit for different reasons. For Justice Gupta, discipline and uniformity in schools was of paramount importance. For Justice Dhulia, on the other hand, the barrier-free education of girls outweighed all other concerns. Two-judge benches of the Supreme Court presented another obvious problem, especially in sensitive cases like this one. What happens if the judges on these even-numbered benches disagree with each other? The court then has no option but to start from scratch with a larger bench. Senior lawyers at the Supreme Court, such as Mr. Fali Nariman, have criticized two-judge benches for adding to the court's burgeoning pendency problem and for delaying resolution. Previously, SCO reported that despite sweeping administrative changes, pendency stood at 69,461 cases on October 1st, 2022. Some of the students challenging the ban requested that the Sabrimala Review 9-judge bench should hear the hijab ban case. Justices Dhulia and Gupta rejected this request. If the new bench overturns their decision on reference, the hijab case will get resolved only after 9 judges decide the validity of the Essential Religious Practices test. Many hope that the Sabrimala Review will be the judgment to give final clarity on the ERP test, which has already been subjected to intense scrutiny at the Supreme Court. What happens next? The Chief Justice will decide which 3 judges will start fresh hearings on the hijab ban challenges. Lawyers on either side of the debate will benefit from both judges' decision to emphasize their arguments. Justices Gupta and Dhulia heard a wide range of arguments spanning the rights to education, equality, religion, privacy, dignity, liberty, fraternity, and free expression. The overwhelming focus before this bench was on the contentious ERP test, even though all parties and the judges as well agreed that it should not form the basis for decision. Interestingly, the court still spent a majority of its time hearing ERP arguments. A long road lies ahead in the hijab ban challenges. A final answer is unlikely in the 2 working weeks remaining in CJI Lalit's tenure, leaving the ball squarely in next in line Justice D.Y. Chandrachud's court.